Now, Trade Union Solidarity plans to challenge the newly enacted Employment Equity Act in courts. It comes after President Cyril Ramaphosa signed the 2020 Employment Equity Amendment Bill into law. In a statement, the presidency says the bill promotes diversity and equality in the workplace. However, Solidarity says the legislation excludes other races. For more on this, we're joined on the line by Dirk Hermann, the CEO of Solidarity. Very good evening to you. Thank you so much for your time. President Ramaphosa signed this bill into law, which seeks to advance transformation of South Africa's workforce. You're saying the act is unconstitutional. Why is that?
Yes, it simply goes too far. If you look at this specific amendments, what happens is that the Employment Equity Act is now transformed in a program that is a strict numerical race tally program, and that is then centrally planned by the minister. So it took away the affirmative action element and replaced it with absolute race element. And this is not permitted by the South African Constitution, and it is also not according to the international conventions that we've, as South Africans, signed. So the fact of the matter is that we sit now with a problem that we have a strict, rigid affirmative action program, and that is not allowed by the Constitution, neither by the international conventions.
So you say that you wrote to the President after obtaining legal opinion, which backs your remarks and your dissatisfaction. What response did you get?
Well, we only got a response from them and acknowledging the fact that we wrote to them. They did not do anything with that. In fact, as they just continue and sign this specific law. And we've stated in the letter quite clearly what the reason is why this is unconstitutional. And we also showed them what the International Labour Organization's Resolution 111 and the United Nations Third Convention says. And the fact is that we must adhere to the specific conventions as well. And if you look at the conventions, it's quite clear that affirmative action must be flexible. It must focus on training. It must take into account the socio-economic position of people. And what's very clear is that you can't take race as the only or the most important criteria. Then it goes too far, and then you can't be defined as affirmative action or, like the UN statute, a special measure. Then it's simply too far, and that is what happens now in South Africa.
So with this act, which imposes race targets on all sectors, you're saying that the new definitions under the Act of designated employers will be costly in terms of jobs. How do you see that?
Yeah, it will be, because what happened now is that the only criteria that is used is race, and the minister can determine that. So the minister then can, from a national position, determine exact race quotas for a specific sector. It does not take into account that specific sector's challenges and the skills availability in that sector. He can just determine what the race quotas in that specific sector must be. Now, that will be to the detriment of the economy of that specific sector, because you must be flexible. You must take that specific sector in specific needs into account, and that will not happen now. And that will lead to a unfair intervention into the matters of a private company, and that is also limiting the right of the company to do business, and of course the right of certain workers to work.
So what would you say to the critics who may perhaps see this as you asserting your position on non-racialism as underpinned by the principles of the Constitution? What would you say to that?
Yeah, this is not non-racialism, this is racialism, because they use race as an absolute criterion, and they force down race quotas as an absolute. And that is not affirmative action anymore. That is actually a racial manipulation. What we rather must look at, and that is also what the UN prescribed, is that we must look at input-based affirmative action. That's training and development. And the problem is not that the South African companies are not representative of the South African demographics. The fact is that skills are not representative of the South African demographics. And the problem there is the fact that we have 80% of our South African schools that are dysfunctional, and the South African technical training is actually, especially in the public sector, dysfunctional. So the South African government's training initiatives are at this stage dysfunctional. That leads to the fact that we don't have a representative skills base, and that leads to an unrepresentative demographics in the workplace. So the problem here is actually the government that simply don't do their business, and they don't do what they are supposed to do, and that leads to a skills crisis in South Africa. The problem is a skills problem, not a race problem in South Africa.
The President says this bill promotes equality and diversity in the workplace. I mean, as you are preparing to take this to court, what will form part of your legal arguments?
The legal argument will be the fact that it is a rigid approach to affirmative action where you only use race as the absolute criteria on the one side, and the second strong argument is, of course, that the minister gets absolute power to determine race quotas. That actually means that there's no processes anymore, and the private sector is not a role player in determining their specific targets. It is actually announced by the minister. So that can surely not be what the Constitution Act means at this stage.
So when are you preparing to go to court then?
Well, our attack on this amendment is threefold. In the first place, it's the litigation. Our team is quite far. We will finalize our papers this coming week already. But the second attack is at the United Nations International Labour Organization. We already submitted a formal complaint there, and that process already started. And lastly, most probably, we will be in front of the Committee for the Eradication of All Forms of Racial Discrimination of the UN in the beginning of December. And all this action, the litigation and the international actions, we will focus on this unconstitutional and, of course, the contravention of international standards.
Very well, thanks. Let's perhaps leave it there for now. Dirk Hermann, the CEO of Solidarity, speaking there about their dissatisfaction when it comes to the Employment Equity Bill.